Good morning to everybody. Thank you for joining this next in the series of In-House in Focus. My name's Mark Davison. I'm a litigation partner based in our London office, and today I'm joined by Lino.
And I'm a principal associate in our Cambridge office. I've spoken to some of you before about some of the issues that we're going to be talking today.
Okay. So really the purpose of today is just to provide an update on dispute resolution clauses, and in particular where there are cross-border angles to your commercial relationships. I think dispute resolution clauses are often called in the industry champagne clauses. That's because they traditionally sit towards the end of an agreement, and they're sometimes only focused upon very late into the negotiation of a deal and when the deal is about to complete. And I think the problem which Lino and I see is that when you've got poorly drafted dispute resolution clauses, they can create serious issues. And so we'll just talk through some of the issues which arise out of dispute resolution clauses today, and some principles that we'd like you to take away just to ensure that you don't sort of fall into those issues. I mean, I think if there is one takeaway from today which Lino and I would like you to take, I think that's really just to take great care in your dispute resolution clauses, because you can have the best contract in the world, but if there's a poor dispute resolution clause there, it might not get you the relief that you need. Just very quickly, just in terms of some housekeeping, as always, there'll be a recording and a presentation available, which my colleagues will send around once we've completed the webinar. There's a Q&A function as well, which hopefully you can access at the top of the screen. Feel free to ask as many questions as you'd like. The Q&A is anonymous to the other people who are attending the webinar. So please do put your name so that Lino and I can see it, just in case we're unable to address your question during the webinar. What we'll do is we'll try and follow up afterwards. And then finally as well, once the webinar has finished, there should just be a quick feedback form as well, just setting out what your views were of today's webinar. So just in terms of what we'll cover today on dispute resolution clauses, again, as I said at the start, we're just particularly focusing on where there's a cross-border angle to your dispute resolution clause. We're going to look at where we are at the moment when you're dealing with counterparties in the EU, and in particular look at something called the Hague Convention 2005. We'll look then at possible future developments that in the context of the Hague Judgments Convention 2019, which you may or may not have seen that the EU and Ukraine acceded to last month, and that comes into force on the 1st of September 2023. We'll then look at sort of dispute resolution clauses generally when you're dealing with parties outside the EU. I'll quickly look at arbitration clauses and the advantages that arbitration can provide when you're dealing with parties from other jurisdictions. We'll then quickly look at tiered dispute resolution clauses. I'll just very quickly touch on something called the Singapore Mediation Convention 2020, which you might not be aware of. And then just finally, we'll look at just some top tips for drafting dispute resolution clauses. So just in the context of where we are now, Lino.
I'm just going to talk about just as a quick refresher, where we were before we left the EU. So the old regime that was in place in relation to issues of jurisdiction and enforcement was something called Brussels Recast. This was a set of harmonising rules that set out rules to determine which countries' courts had jurisdiction to deal with the disputes and how and if judgments would be recognised abroad. And it generally meant that when you came to draft clauses like exclusive or non-exclusive jurisdiction clauses, there would be a set of rules that you could expect that could be applied across the EU. It also meant that if proceedings were issued in an incorrect court, there was a mechanism for dealing with getting them in the correct court, and it also allowed for judgments to be portable between states without too many hoops. And it also allowed for you to be able to obtain some sort of interim relief if you needed it. That regime does still apply to cases that are issued in England before the 30th of December 2020, but now that we've left the EU, it no longer applies. Having now left the EU, there's been a lot of debate as to exactly what convention might replace this, if any. And at the time, when there were negotiations going on with the EU over what was going to replace it, the UK's preferred approach was always to join something called the Lugano Convention, which is in practice is very similar. That's a convention that governs jurisdiction and enforcement of judgments between the EU and the European Free Trade Association states of Switzerland, Iceland, and Norway. It largely operates the same way that the Brussels regime used to, and so it was very practitioners here used to think that that was probably the most likely solution. The UK submitted an application to accede to that convention in April 2020, and although the EFTA states are largely supportive of the UK joining it, the EU hasn't, and the Commission largely stated it wasn't minded to recommend accepting the UK's acceptance, and I think that seems to be unlikely to change. Their view was that the Lugano Convention was largely there to support a common market, which the UK was coming out of. And unless that changes, and we haven't seen any indication that will change, it looks very likely that we won't be able to take the benefits of what we thought would be the next best thing in the Lugano Convention. So what that effectively means is that we would be then looking at, when it comes to rules about what jurisdiction clause to use and whether or not your judgments obtained in one state would be enforceable in another, we are going to be looking at other conventions outside of Lugano.
Yeah, so just in the context of where we are now, sorry if I can get the next slide on. So I think where we are now is if you want the benefits of an enforcement treaty in order to, especially when you're dealing with EU counterparties, and you want the benefit of that enforcement treaty just to streamline the enforcement process in an EU member state, we're going to have to rely on something called the Hague Convention 2005. That might change in a year or so because of the Hague 29 Convention, which I'll come on to. But just in respect of the Hague Convention 2005, just to summarise what it is and how it works. So if you fall within the Hague Convention requirements, effectively what happens is that the court that you specified in your dispute resolution clause is obliged to hear the case, and any other court where a set of proceedings is brought must refuse the case. And then once the judgment has arisen from those proceedings, it will then be recognised and enforced in another Hague Convention state. So the people who have ratified the convention there are on the screen. So if you get a judgment from a UK court and you need to go and enforce that in Italy, provided you fall within the requirements of the Hague Convention, which I'll come on to, that will have to be enforced in Italy. Equally, if you need to enforce it in Singapore, it's the same principle. The Hague Convention 2005, though, only applies where you have a dispute resolution clause which expressly states that it is an exclusive jurisdiction clause which is entered into after the convention came into force in that particular state. It also only applies to international agreements. And what I mean by that is that it effectively has to be between parties from more than one member state. So, for example, you can't just have two English parties to an agreement, have a French jurisdiction clause, and then have the benefits of the Hague Convention, because that's not an international contract. So, do you just want to quickly touch on who's sort of ratified it? And
yeah, so the current position, as Marcus said, is that it has been ratified by the EU, Mexico, Montenegro, and Singapore, but none of the other what we call Lugano states, so Switzerland, Iceland, and Norway, haven't yet ratified it. The US and China have signed the convention but haven't yet ratified it. We're not clear at this stage at what point they would come in. There's often a time lag between these conventions being signed and then ratified. We haven't seen that there's anything to suggest that the US is taking steps to ratify it. The Chinese Ministry of Foreign Affairs has indicated that it does wish it to come into, that it probably will be ratifying it shortly, but we're not quite clear when. There is, however, a bit of an issue that we've identified between the EU and the UK as to exactly when it's treated as having taken effect in the UK. For drafting new clauses, that doesn't matter, but for historic clauses, it does create a bit of a problem because the EU ratified this convention in October 2015, and the view of the EU is that it only applies to the UK from the point at which the UK effectively left the EU on the 1st of January 2021. Of course, the UK doesn't share that view, but what it does mean is that if there is a dispute involving a country who is or a party who's based in another EU member state, and there are proceedings that are having to take place either in that state or you're looking to enforce it, there is going to be a question mark for that state to determine whether or not the correct date is 2015, as the UK says, or whether it's 2021, as the EU says. So we don't know how that will. Well, we don't know how that will plan out. How it will pan out.
If I just briefly look at just some examples as to dispute resolution clauses, just to ensure, well, just to what the position will be as to whether they will be compliant for the purposes of Hague Convention 2005, to give you those streamlined enforcement prospects under the convention. So I put some examples there on the screen. The first one is what I said earlier in terms of it is specifically states that it is an exclusive jurisdiction clause to settle the dispute before the courts of England and Wales. And so that is a compliant clause for the purposes of Hague Convention 2005. The second provision there, whilst that doesn't actually state exclusive jurisdiction, the way that it's in the explanatory notes to the convention, there is guidance there that that type of clause will be deemed compliant for Hague Convention purposes. I think the problem arises in the third example there, and I'll explain the issues with the fourth and fifth example as well. So the third example, you've expressly agreed that the preferences of the dispute will be heard by the English courts, but actually it has non-exclusive jurisdiction. So that basically means if you need to bring proceedings in another jurisdiction and there are a procedural basis in which that jurisdiction should be seized of the dispute, then you can do that. But if you have that type of clause, then for the purposes of Hague Convention 2005, that's not going to be compliant. You might question, why would a party want that type of clause in the third example there? So they're common, for example, in banking arrangements where a lender might just want to have the option of where it is that they need to bring proceedings in order to try and enforce the debt that it has against the borrower. Just in respect to the fourth example there, this is what we call an asymmetric clause. So this is effectively one party is bound that it has to bring proceedings in one particular jurisdiction, but the other party effectively has the option of wherever it wants to go in order to bring proceedings. Again, these are quite common in banking arrangements. Again, just the same reason that the lender wants the ability to bring the proceedings where it thinks there are best prospects of being able to enforce its debt. The fifth carve out there as well, I should add the fourth example there is not compliant for Hague Convention reasons. The fifth example there is what we call a carve out. So effectively, you said the courts of England and Wales have got exclusive jurisdiction to settle the dispute, but if you need to seek interim relief from a particular court, then a party's got the option to go to a court of another jurisdiction in order to get that interim relief to protect its position. And so those types of clauses are quite common in IP arrangements, because if you're somebody who is effectively licensing your IP to another party, you might want to just have the ability to be able to go and get interim relief from a particular jurisdiction where your IP rights are being infringed by the person that you've licensed your IP to. So just a quick summary of where we are just on asymmetric clauses and carve-outs. So the position with asymmetrics is that it has been debated before the English courts as to whether they're compliant for Hague Convention purposes. And in fact, there has been some conflicting decisions at first instance. But the reason why we consider that they're not compliant for Hague Convention requirements is because of this Court of Appeal case called Etihad Airways and Floater. And the Court of Appeal held, although on a no-beta basis, that it wasn't prepared to proceed on the basis that that type of clause, the asymmetric clause, should be interpreted as being compliant with the Hague 2005 Convention requirements. I should just note as well that if you're looking to draft asymmetric clauses as well, you just need to be aware of the particular jurisdictions where you might need to go and enforce any judgment that you get, or where you need to bring proceedings, because in certain jurisdictions, asymmetric clauses are void and ineffective anyway. So I've given an example there of France, where there's been a stream of decisions, mainly involving banking cases involving Credit Suisse and Rothschilds, where effectively the French Court of Cassation has held that such clauses are void and ineffective. The position about carve-outs is a little bit more interesting, because there isn't a case, as far as Lino and I are aware, where this has been tested as to whether a carve-out should be, whether a carve-out falls foul of the Hague 2005 Convention requirements. It's actually silent both within the explanatory text that comes with the Hague Convention 2005, and also something which is called the Hartley-Dugacci report, which was effectively the report which comes with the Hague 2005 Convention, effectively setting out why each particular article in the convention has been drafted in the way that it has. I've had some debate with other practitioners as to whether or not such clauses would be compliant for Hague 2005 requirements. And I think sort of ultimately where I've got to, having spoke to an academic about, an academic who's drafted the leading textbook on effectively what the impact of Brexit is on private international law, is that whilst it's silent in the convention and within the explanatory text, that given what the option of the carve-out gives you, namely that you can bring your interim relief application in any other particular court, that it's because of that that effectively means that that will not be compliant for the Hague Convention requirements.
So there are a few other points just that flow on from this. As Mark says, there's a bit of a question mark over what the situation is if you have a clause that has a carve-out in it that allows for interim relief, and whether it brings it within the Hague Convention or not. There is a further point here about this convention also dealing with the ability to be able to recognise judgments in convention states, and the general principle when you are looking at recognising judgments in one state to another is that they need to be final and binding. And so the issue, as matters stand at the minute, even if you did manage to get an injunction or any other kind of relief in one state, there's no guarantee or any provision in the convention that allows that to be recognised and enforced in another. And so if you are thinking about what clauses to put into agreements, there are some decisions that, or some more finely balanced decisions now to make about whether or not to make a clause, for instance, exclusive so you get the protection of the convention, or actually whether you need to think about taking it out of the protection that the convention gives you, but allows you to go to the foreign court to get whatever protection you need. And a good example of this, Mark gave an example of IP, but another situation where you might need interim relief is something like a breach of confidence, which might come out as part of a non-disclosure agreement or something like that. It's all very well having an exclusive jurisdiction clause in there, but if you can't actually protect the breach or prevent the breach from occurring in another country, it's going to defeat its purpose. Another important issue here is that the Hague Convention also has a fairly narrow ambit in relation to civil and commercial matters. What it doesn't deal with is disputes involving consumer law or employment in particular. There are specific rules that will still apply to those. And it does mean that if you've got terms and conditions where you're dealing with consumers, then the protections of the convention won't apply there either. We've also talked about what the position is in relation to the views of the UK and the EU on when the convention takes effect. That shouldn't present difficulties when you're drafting agreements now, but obviously the historic agreements where there may be some question marks over enforcing those, you just need to think about the impact of where you might want to proceed and how you might want to enforce that. Well, we are going to come on to talk about what happens if the Hague Convention 2005 is not engaged, but as a sort of a precursor to that, as you can see, the general position is going to be that you're going to be looking to local laws, and all the conventions that we have got in place that deal with consistency are not going to be engaged. And as we say there, it doesn't impact arbitration, and Mark will come on to talk about how arbitration might be an alternative to the problem that this has created.
Before we come on to that, just to look at, in terms of the Hague Convention 2005, just to look at sort of the direction of travel and what's coming down the track. So I've put there whether the 2019 convention is coming to a jurisdiction near you. So I think I mentioned at the start of this that the Hague Convention 2019 was acceded to and ratified by the EU and Ukraine late in August last month. Because of the way that the treaty operates, so the convention operates, it won't come into force between the EU and Ukraine until the 1st of September 2023. But the UK at the moment hasn't sort of announced what it is intending to do in respect to the Hague Convention 2019. But also I'll come on to what the benefits of the Hague Convention 2019 are. But because of that, I suspect that, well, certainly Lino and I both anticipate that the UK will look to ratify the Hague Convention 2019 soon. And effectively, what the Hague Convention 2019 is effectively a treaty which is trying to operate in the same way as what the New York Convention 1958 does for arbitration. So effectively, it's trying to be the court judgments New York Convention, effectively. Really, the reason why it's of particular interest is that the issues with Hague 2005, in the fact that it doesn't apply to non-exclusive jurisdiction clauses, situations where you've got asymmetric clauses or those carve-outs, they fall away under the Hague Convention 2019, provided that your judgment debtor has consented to the jurisdiction. So a lot of the headaches which have been caused by the fact that the UK has left Brussels recast should fall away once it's ratified and joined the Hague Convention 2019. I should say at this moment, whilst it's supposed to be this worldwide enforcement convention, effectively for court judgments, there are relatively few states that have actually signed the convention so far. So I put them there on the screen. None of those states have ratified it. It's only the EU and Ukraine which have ratified it so far. But I think it's certainly one that we should keep an eye out on, because that should alleviate a lot of the headaches, especially when you're dealing with EU counterparties, in respect of just ensuring that you have a streamlined process for enforcing any judgment that you get following a dispute with your counterparty.
What then if you're dealing with a situation where you've got a party that's not in a Hague Convention state or not in the EU? The basic position is that if you are going to either pursue or try and enforce rights against parties based there, you need to really be thinking about how the judgment that you would get at the end of it would be enforceable. And usually the question is, where are the assets based? As a matter of English law, once you get outside the conventions, there are only really a handful of statutes that apply or govern very fairly limited countries to explain how judgments from overseas would be enforced here, and the same applies in reverse as well. In many countries, or their national laws provide that enforcement is based on reciprocity. So, if, for instance, if the UK recognises a judgment of another state, or there is a reported case on that, then it will generally they take the view that they would enforce our judgments in return. But there are some quirks to this, because although the example we've given there is Kuwait, that's a particular example, because although under Kuwaiti law they do recognise the concept of reciprocity, there's no reported UK cases of a Kuwaiti judgment being enforced in the UK. So as a matter of principle at the minute, there isn't, you wouldn't be able to get a judgment in the UK enforced against a party based in Kuwait. So in order to try and think about how you might enforce that, you might have to go to some indirect routes. So, for example, taking the English judgment to another state where it does recognise a UK judgment and then taking that foreign judgment to the Kuwaiti courts as some bit of a circuitous route. And I have done that before under some of the old regimes where we've had judgments against parties in, say, Luxembourg, where we've been looking to try and get those judgments enforced against assets in Hong Kong, because there's no reciprocal enforcement regime between Luxembourg and Hong Kong, but there is between the UK and Hong Kong and the UK and Luxembourg at the time. These are all real difficulties, and of course you hamper yourself if you've already provided in your agreements that certain courts will or won't have jurisdiction. So the idea of thinking ahead as to where you might want to enforce your claim actually really does. This is one of the really key examples that Mark gave to the issue Mark raised at the beginning, which is that when we look at this at the end of the deal, when you're trying to enforce your rights, a really badly drafted champagne clause, as we put it, can really scupper at your ability to be able to enforce your rights. There are a few other sort of lesser known enforcement treaties, including a number in the Middle East. But as I said, usually if you are thinking about or contracting with parties who are based in some of these more exotic jurisdictions, there is no real substitute for getting advice in that local jurisdiction about how rights can or can't be enforced. Because even something as benign as a carve out in an agreement to be able to allow you to go and get the rights or enforcements you may need may not be recognised or enforceable at all overseas. As a matter of general principle, most jurisdictions only ever recognise judgments that are final and binding. So it really is quite important that you think about how you enforce those rights. Again, the answer to that may well be arbitration, which Mark will come on to discuss now.
Yeah, I should just add that what Lino was talking there about reciprocity. There's something about 2 or 3 weeks ago that I saw, which came out from the Dubai Ministry of Affairs, which was a direction to local onshore Dubai judiciary, saying that because there has been an English court judgment which has recognised a Dubai decision, then the judiciary in Dubai should therefore now enforce English judgments on the basis there is that reciprocity there between the way that the UK courts deal with Dubai judgments. So I think, as Lino sort of posed, is arbitration the answer? So I think, as Lino touched on, Brexit hasn't had an impact on arbitration. And it hasn't had an impact on arbitration clauses and the way that they would be treated by EU member states as well. Just for those of you that I'm not going to talk too much about what arbitration is and what the benefits and the advantages and disadvantages of it are, but just for those of you that might not be that familiar with arbitration. Effectively, arbitration is a private form of dispute resolution where the parties have agreed in writing that they want to refer their dispute to be resolved by an arbitrator or a tribunal of arbitrators. It leads to binding decisions, but the beauty of it is that there is effectively the enforcement regime which you get under the New York Convention 1958, which has been ratified now by 169 states around the world. So you'll be hard pushed to find a state which hasn't yet ratified the New York Convention 1958. And the way that the New York Convention 1958 is supposed to operate is that a member state is required to uphold and enforce an arbitration award made in a foreign seat, provided that it doesn't fall foul of a couple of requirements, one of which is around public policy. So if an arbitration award is contrary to public policy of a state where you're trying to enforce, then sometimes the courts in those jurisdictions will then set aside the award. So that there are naturally some horror stories which occur. So I think there was one very recently, a couple of months ago in Qatar, where the arbitration award was set aside because the arbitrator had signed the final page of the arbitration award, but hadn't signed each individual page through the award. there was a very famous case in the early 90s in Dubai where a very large arbitration award, which had been issued in Switzerland about works on an airport, wasn't recognised by the Dubai courts on the basis that the witnesses had been affirmed in to give their evidence rather than swearing on oath, so on a religious book, that the evidence they will give during those proceedings will be the truth. But slowly but surely, the position is even in less developed jurisdictions is getting better. So there are various instances now, for example, in the UAE, where arbitration awards have been recognised and enforced. And as I think as regimes, particularly judicial ministries and judiciaries get more experienced about arbitration, even in sort of more exotic jurisdictions, as Lino put it earlier, arbitration awards will become increasingly more recognised. But you'll be hard pushed, though, to find a regime which operates like the New York Convention, which applies to court judgments. So just about arbitration clauses, if you're interested in arbitration and effectively agreeing an arbitration clause in your agreement, either speak to a legal team about drafting that arbitration clause for you. I mean, a lot of the institutional centres actually, so the institutions that will administer arbitrations for you, have model arbitration clauses on their websites. There's a couple of points that you might just want to consider. So, for example, do you want to carve out within your arbitration clause, which means that you can try and get court injunctive relief? There is a debate about the way that operates. If you've adopted an LCIA arbitration provision in your contract, but you then want to go to the English courts for injunctive relief, there is a slight debate as to whether or not the English courts now have power to do that following a case called Gerald Metals and Timmy. So in order to get around that issue, if you expressly state in your arbitration provision that there is a carve out for injunctive relief, you don't fall foul of that issue which arose in Gerald Metals. Another issue which I sort of often consider in my arbitration clauses is just considering if the parties are from different countries. So you're a UK registered company and you're transacting with a French company, but you want an LCIA arbitration clause seated in London. Because those parties are from different countries, under the LCIA rules, you have to select an arbitrator. So the LCIA will appoint an arbitrator who is a different nationality to the UK and the French counterparties if the parties can't agree their arbitrator. So it just effectively just reduces the pool of arbitrators that you can select from, which is a shame, especially if you've chosen English law to govern your contract. So that's really just some very quick tips there about arbitration provisions.
I'll talk very quickly about tiered escalation dispute resolution clauses. We are running a bit short of time, so I will run through these very quickly. These are clauses we commonly see often as boilerplate that are put in towards the end of the agreement as well, and they set out what steps should be taken before either a claim or an arbitration is commenced. And examples of what they can include and what they typically include are things like time structured meetings between authorized individuals. Mediation is another example, or either an evaluation process or an expert determination process. We all see these sorts of things in dispute resolution clauses. I've got really two observations in relation to these clauses. The first is that if you are going to include a clause like this, it needs to be clear what needs to be done and in what time frame, because parties need to be clear what steps it is that they need to go through. And the second of these is that we also need to take care as to whether people are actually properly engaging in that process or not. And that matters for a variety of different reasons, but also because in relation to, if there are clauses that provide that these steps have to be gone through before you can commence litigation or arbitration, that could actually be an obstacle to either commencing either of these two processes. And certainly in relation to an arbitration, if there is a provision in there that says that the parties are to take part in these discussions in good faith, which you often see in these clauses, there may be a question that could be lobbed in the arbitration, but actually the dispute itself hasn't crystallized, and so the arbitration can't commence until that stage has been reached. We are aware that there has been a debate for some time about if you have a dispute resolution clause, whether you can commence court proceedings before these steps have gone through. But generally speaking, the only effect that could really have is the court might be prepared to stay proceedings, but it probably wouldn't go as far as saying you couldn't commence them. But that's something I would raise. These clauses are there not to be paid lip service to. They should be genuine mechanisms to try and resolve the dispute, but just be careful about what you wish for if you do put these in.
Yeah, just to add to that very quickly, and in context of arbitration, if you have these tiered escalation clauses and you don't follow the process through them before commencing arbitration proceedings, the respondent who you're suing will have a pretty good argument to say, actually, the dispute hasn't crystallized because you haven't gone through these steps, and therefore the tribunal doesn't have jurisdiction yet to determine that dispute. And so therefore, effectively, those proceedings got to be stayed or effectively ended to allow the parties to go through the tiered escalation clause first before then effectively recommencing the arbitration. So, again, I think as Lino said, we're just running a little bit short on time. Just really quickly on the Singapore Mediation Convention. Appreciate many of you might not have heard of this, but effectively what this convention does is, usually in the context of mediation, it's a decision taken by parties when a dispute has arisen, either before they commence court proceedings or arbitration proceedings, or something which they do through the proceedings. And so what the Singapore Mediation Convention is designed to do is effectively try and have an enforcement regime for where there is a settlement agreement which is entered into post a mediation. Again, it's not been ratified by that many states yet. I think at the time of this webinar, there's only 10 which have ratified it so far. The UK government has had a consultation about it. I think we're still waiting for their recommendation. But the reason that I raise it, just so that it's of interest for you, and just so that you're aware, actually, there may be a way to enforce, a decision against, an agreement against a party which you have overseas through the back door by effectively getting them to mediate and then trying to enter into a settlement agreement post that mediation.
So we'll just conclude with a few tips in relation to drafting dispute resolution clauses. I would say this is somebody who looks at it from the back end, but I would always say when you are drafting clauses like this, they are in the agreement for a reason, and they're there to make sure that you can enforce the rights. So if you are dealing with parties overseas, think about where will I need to enforce my judgment if it's gone wrong? Where are those assets going to be? Jurisdiction clauses and governing law clauses get mixed up. A governing law clause is what law governs my contracts. So do think about them as separate agreements and think about where you want to bring the proceedings. We've talked about the fact that we've got protections in place dealing with exclusive or non-exclusive jurisdictions. It really is now much more of a finely balanced decision about whether or not you have an exclusive or a non-exclusive jurisdiction. As a general rule of thumb, the advice I tend to give is that if you are likely to want remedies very quickly, or you want remedies that are things that are not damages, so an injunction, there may be more benefits to you having a non-exclusive jurisdiction clause to allow you to go overseas. If you are dealing with asymmetrical unilateral clauses, you need to think about the effect of those and actually whether that is going to work or not. And I would encourage you to also think about getting advice in the local jurisdictions as well, because as Mark has said, there are quirks as to whether these clauses do or don't work. The same in relation to seeking interim relief. Mark has talked about some of the benefits of arbitration, and a common misnomer is that arbitration is expensive and difficult. And in fact, actually, a number of these arbitration rules do provide for more streamlined processes. And given that there are difficulties with enforcement, And that offers a pretty solid route to enforcement. Actually, it doesn't quite have, it has a reputation on an expense that it perhaps doesn't deserve, but it's certainly worth thinking about, and do speak to them or get advice if you are being asked to put these clauses in, because they are often, there are benefits there, certainly now.
Just as an example of that, the ICC, if you have a dispute which is under $3 million in quantum, then the tribunal has to raise an award within 6 months of the first procedural conference in the arbitration, which happens fairly early on within those proceedings. So actually it's a fairly streamlined way of getting an award in an arbitration if you've got that value of a dispute under $3 million. If you think about it, if you want to try and get summary judgment in English court proceedings, it's still going to take you 3 to 4 months anyway.
Yeah, I would agree with that. And if you have tiered escalation clauses, make sure the steps are very clear and follow them if they are going to be if they're going to be used.
Okay. So again, I think as Lino's touched on during the webinar, I think care does need to be taken around dispute resolution clauses. If you've got a counterparty who is based overseas and you're not sure about what the best way to route your jurisdiction clause to give you the best chances of being able to enforce that judgment against them, then please do get in contact with us, because we're able to help. We're sort of quite well versed now in terms of trying to set up mechanisms of just trying to ensure that you've got the best prospects of being able to recover monies or to enforce your rights if something goes wrong under your contract with a cross-border party. So just in respect of questions, so we've got some here on the screen. So I think a lot of these actually were raised during the session. There's one here just about the pros and cons of interim relief carve-outs. So the benefits of it are, I think that example that I gave, if you've licensed your IP rights out to a counterparty, and then you learn that actually they're infringing your IP rights, but they're doing it in a jurisdiction which isn't the jurisdiction where you've got your jurisdiction clause. Effectively, because you've got that carve out, you've got permission then to bring the interim relief application to effectively seek interim relief for them to stop infringing your IP rights in that jurisdiction. The problem is if you've got an exclusive jurisdiction clause without the carve out, is effectively you'd have to go to the English courts to try and get the interim relief. And then there's a debate then as to, because it's not a final award, as to whether that can be enforced in a foreign state. So it can just create headaches if you've got potential where your IP rights might be enforced overseas. There's one here about what choice of law should you make to underpin the arbitration. So that's a fantastic question. So the way that the arbitration agreement operates is certainly as a matter of English law, and in sort of most jurisdictions where I've looked at this issue, is the arbitration clause is effectively treated as a separate agreement that just sits within your substantive agreement. So it's a standalone provision. And so you've got the substantive law which will govern the obligations between the parties in the substantive part of the contract, but then there is their own governing law for the arbitration agreement itself. And if it's not specified within the arbitration agreement, there can sometimes be a debate as to whether actually it's a different law which applies to the arbitration agreement than actually the substantive law of the rest of your agreement. And so if I give you the example of a UK counterparty enters into an agreement with a Russian party, they choose arbitration to be seated in Paris, in France, but actually the obligations are performed in Italy. And just to say for the sake of our argument, the parties have chosen German law. to govern those obligations, you can see there is a debate there as to which law applies to the arbitration agreement. Should it be German law, because that's what the parties have selected? Should it be French law, because the seat is in Paris? And there was a Supreme Court decision called Enker and Chubb about a year ago, which has now set out what the test is in that type of scenario for which law applies to the arbitration agreement. But again, if you're entering into something where you've got a seat which is based outside of the UK with a foreign counterparty, again, you might just want to seek legal advice on that just to make sure that there's no issues which might arise from that. And the reason why it's relevant is effectively the law of the arbitration agreement will dictate what the procedure of the arbitration is. And there are certain differences, say, between English law and French law, for example, on certain arbitration procedures. So I think just given the time available, we'll just look at one more question. So just what was the issue in the Gerald Metals and Timmy's case? So if I take that one to Lino, yeah. So that was an issue. So under the LCIA rules, so step back, parties has entered into an agreement with an LCIA arbitration provision in it. Both parties, I believe, was domiciled in England, and English law was substantive law of the contract. The LCIA rules have now got what they call an emergency arbitrator provision. So effectively, if you, at the outset of the proceedings, before actually an arbitrator has been appointed, you need to get interim relief from an arbitrator. Classic examples are if evidence is being destroyed or assets are being dissipated. The LCIA rules now provide that you can go to the emergency arbitrator to get an interim award to effectively preserve the status quo of the arbitration, effectively to stop the dissipation of assets, etc. And the issue was that actually in that case, the party had applied to the English court effectively for the interim relief to stop the dissipation of assets or the destruction of documents. And the court of first instance turned around and said, well, actually, because you've got this option now under the LCIA rules to go for emergency arbitration and seek the interim relief from the emergency arbitrator, the English courts can no longer assist. And that's created a few headaches certainly for arbitration practitioners like me. And so the way that we get around that is effectively with the carve out in the arbitration agreement, in your agreement. And we expected that the LCIA itself might try and deal with the issue in the rules that it updated, so the LCIA rules that it updated in 2020, but it hasn't dealt with that issue. So certainly for the time being, until Gerald Metals is overturned, I think the safest route that we're sort of advising clients is to just have the carve out within their arbitration agreement. So I think I'm just conscious that we're now sort of 10 to 11, and we're usually sort of around 45 minutes with these sessions. So again, thank you very much for joining today. It's been a pleasure to talk to you about dispute resolution clauses, and it's certainly quite an exciting time in the context of the Hague Convention 2019. I think at the end of this session, there will be a feedback form which should hopefully pop up. So please do provide your feedback. I think my colleagues will be in touch as well about the next seminars which are coming in the in-house in focus series. So again, just from Lino and me, I'd just like to say thank you very much.
Thank you very much.